I see Tandy Susan's not going to be here. Good afternoon, everyone. Welcome to Banking and Consumer Affairs Subcommittee. I'm your host, Kevin Vaughn. And yes, that's right. You are getting an encore performance for me today. My agent has already spoken with the Speaker's office about increased pay for doubling up today. Before we get started, well, I'll tell you what. First off, we can't get started until we take a roll and declare a quorum. Mr. Clerk, you want to open the board? All righty. Let us know what it is.
Mr. Chairman, you have 5 members present. You have a quorum.
All right. I want to let everybody know the reason I'm sitting here today. This is usually in the capable hands of Representative Darby. However, he is at the SEC Ladies Tournament today, where the Lady Vols put a whooping on the Lady Aggies of Texas A&M. And guess what? Both of his daughters got in the scorebook today. Edie knocked down a 3 and Tess had 2 points. So I don't know how often that happens in the lore of the Lady Vols, but the Darby girls both got in the book today. So I know Dad's busting with pride. Has anybody got any personal orders today before we get started? I do want to let y'all know that this time of year, we're stretched pretty thin with all committees and subcommittees whirring. So at some point, I'm going to have to step out and go present a nominee in another committee, and then I'll come back in. But during that time, I'll pass the gavel to the very capable hands of Speaker Pro Tem Marsh. But if we have no personal orders, let's get right to our calendar. First off, we're going to start with House Bill 443 by Chairman Hulsey. We've got a motion and second.
Thank you, Mr. Chairman. Thank you, committee. I appreciate your time, and I'm glad to be here. This bill came up last year and made it out of the first committee, went to full committee, and then it was sent to summer study. And I tried very, very hard this past summer to get a summer study, and it never came to fruition. So we're back with your committee. This deals with the Uniform Commercial Code. And my bill just does 2 things. It changes 2 things in the Uniform Commercial Code, and that's all. There are folks that oppose this bill, and you will hear that when this deals with stocks, and that's what it deals with, is stocks and your property in stocks, that you'll be told that you have priority, except you don't when there's an insolvency and a bankruptcy. You'll be told that you have property rights, and you do, except you have no right to recover your property rights in an insolvency. You'll be told that no customer lost anything in Lehman collapse in 2008 when they went under. Well, nobody lost anything except the clients whose assets were taken. You'll be told that an agreement is required, that only property for which the customer has given consent is used, except that all securities may be used as collateral by others. And so what this bill does just changes 2 things. And it says if there's an upline insolvency and a bankruptcy and your collateral, your stock has been used as collateral for loans from big banks, this bill does 2 things. It says if you have to sue to get your money back, you don't have to go to New York and sue and get a New York lawyer. And the second thing that it does is that it says that instead of the priority being at the top of the list, the big banks who used your collateral or used collateral of your stock for loans, instead of them being first to get the money back, it inverts that and puts the stockholder, who's now called an entitlement holder, by the way, puts him at the top, or puts you at the top to get your property back and your money back first. That's all it does, those 2 things. And if you'll indulge me, Chairman, there are 2 folks here to testify on this bill. One is Don Grandy, who flew in from North Dakota to be here. And the other one is David Tice, who flew in from Texas to be here. David actually is the lawyer who wrote my bill. So if you would indulge me and let the committee hear from them, I would appreciate it.
That sounds great, Chairman Hulsey. If we have no objections, we're going to go out of session and hear from these fine gentlemen that traveled great distances to pour forth knowledge upon us. We're out of session. If you would, gentlemen, if you would give your name and who you're with for the record, and then I'll tell you what, I'll give each of you 5 minutes for your statement.
Very good. Thank you, Chairman. Is this working? Thank you, Chairman. My name is, and members of the committee, my name is Don Grandy. I'm an attorney in private practice. I've been working on UCC-related issues for quite some time and on this topic for just over a year. I'm here representing True North Public Policy, which is a public policy consulting firm we've established to deal with this issue because we're working in several states. So as Representative Halsey has said, there was a revision in it's called the 1994 UCC Article 8 revision. And I'm going to try not to get into the weeds too much on the terminology and things, but it was passed in Tennessee in 1997. And what that change did, Article 8 of the Uniform Commercial Code deals with investment securities, stocks, bonds, mutual funds, exchange traded funds, that type of thing, your state pensions. And the 1994 amendment made a couple of significant changes as the technology and things were evolving. And so what they did is they created a new type of property right called a security entitlement. So when you call up your broker and buy 100 shares of Apple Computer now, you are not a shareholder. You don't own those shares. You're an entitlement holder, and you have a security entitlement that's related to those shares, but it is different than owning a piece of paper, stock certificate. Despite what the opposition might say, there is a significant difference between the two because they had to put a whole Section 5 in Article 8 explaining the difference and how you deal with it. So the interesting thing about this law that was passed is it's actually, I have to tip my hat. It's drafted very, very well, because since 1997, when this law went into effect in Tennessee, none of your constituents probably realized that there was any change. They could still call up the broker, they could buy their stock, they could make changes in their IRA or 401k, and they could sell the stock, they could get the dividends, they could vote the shares if they had wanted to do so. So in all intents and purposes, it gave the illusion that they had full ownership. So that's the beauty of this, is that it continued on since 1997, and nobody really understands what the issue is here. But the issue is lurking within the policy in the statute, Article 8, 511. It talks about priority, who has priority when it comes to ownership rights to a certain piece of property. And Article 8, 511 says basically that the investor has priority to their own property, which is nice to hear, over the general creditors of the broker that they're dealing with. And then it says except as provided in B and C. And those two exceptions are what we're here today mainly to talk about. Exception B is a carve out that gives in the event of the insolvency of your broker or your broker's custodian without your knowledge. If your broker's custodian has a loan with JP Morgan, for example, in the event that the custodian becomes insolvent, the bank has priority to your assets. And that's just fundamentally, it says so right in Article 8, 511B, as long as the bank has control. And I can get into some of those issues if you'd like, but in interest of time, I won't get into that. But they always have control because doing so gives them significant rights. So they're going to make sure they have control. So what the opposition is going to say is that exception in 8511B only applies to margin accounts. And I hate to get a little technical here, but a margin account is where you go to your broker and you say, I want to borrow some money from you. I'll pledge my stock and you'll give me cash because I want to go make another investment. That's a margin loan. Article 8511B has absolutely nothing to do with margin loans by operation of law. And so what happens is that if you went to your broker and say, I want to take out a margin account or take out a margin loan, He's going to say fine, but he's going to have a separate written legal agreement. He's not just going to give you $50,000 on a handshake. You're going to have to fill out a loan agreement, and that loan agreement does a couple of things. It gives the broker priority. You pledged your assets. The broker has a full security interest in those assets, and that written agreement supersedes UCC Article 8. So once you sign that agreement, you're outside of this exception. So the question is, I know I'm probably running short on time, but I can get into more detail if there's interest. So the question is, if 8511B doesn't apply to margin accounts, what does it apply to? And the answer is in your code right now. It's in the annotated, the official comments portion of the code, which I like because I used to use the actual books rather than online, and you could have the annotations in there. It explains exactly what the drafting committee was worried about here, and has nothing to do with margin accounts. They're worried, the drafting committee was worried that if a broker or a custodian did something illegal and used the client assets without the client's permission as collateral for a loan to another bank, the drafting committee wanted to make sure that the banks had priority if there was an insolvency. And that's 100% spelled out in your official comments, and I can go into more detail on that. Don't know where I am on time, but I wanted to be brief on that and just get the gist of the issue out in front of you.
You got her done in 5 minutes, so we appreciate that. Yes, sir. Now, please introduce yourself and offer your thoughts and comments.
So I'm David Tice, very proud to be here today, Chairman Vaughn, members of the committee. So I traveled from Dallas, Texas. I represent only myself as a patriotic American and proud Texan. I'm an entrepreneur, a prior fund manager, as well as a proud American citizen. I'm a chartered financial analyst, CFA, also used to be a CPA before I gave up on continuing professional education. And I understand the financial world very, very well. I've been the founder and a primary fund manager of two different mutual funds that peaked at $1.6 billion that I sold in 2008. I've been on CNBC and Bloomberg about 150 times. I predicted the 1987 crash, the 08 crash, as well as the 00 to 02 crash. So I understand financial markets. I understand Enron, Lehman Brothers, Fannie Mae, Freddie Mac. Actually, I predicted all those declines and made money in my mutual fund during each of those crashes. I just learned about the Great Taking and this particular travesty of justice only about 4 weeks ago. And I agree 100% with all the comments that esteemed lawyer Don Grande, as well as the prepared remarks that came from David Webb, who prepared written testimony. He was the author and the documentary filmmaker for The Great Taking. This is a travesty that we have. The current Uniform Commercial Code has been written to protect the secured creditors of the big financial institutions and essentially takes away the ownership rights of individual private citizens, private corporations, and pension funds. We cannot have this exist in a free capitalist society. In fact, the law was changed so that the security ownership technology was switched from the word shareholding or ownership to the term security entitlement. So this was defined as a bundle of personal rights that one holds against their broker. So can you imagine that? You're no longer an owner. You're a security entitled, and you're entitled only subject to the rules of this Uniform Commercial Code. Now, this seems very complicated until you realize that the current state of Tennessee, UCC, actually outlines very clearly that the securities intermediary has priority over the claims of the entitlement holders. That means these big brokers and the banks securing loans for the big brokers have priority over you, the little guy shareholder. This truly is a travesty of justice. As Don Grande clearly pointed out, and we know this is going to be argued by our opposition, this has nothing to do with margin loans, as these exceptions, B and C, will be applied to all financial assets. So having predicted several financial crises, I should tell you that I'm very worried currently about the current situation, with the company having $36 trillion of debt, as well as more than $200 trillion of off-balance sheet liabilities. Plus, the dollar remains under significant attack by our major adversaries attempting to end its reign as world's reserve currency. The recent changes to the UCC were characterized by its authors as providing Armageddon planning. Our critics will say that the current financial system needs the code to be in place as it's written today for the financial system to operate. Well, if it requires the capability for seizure of assets from hardworking Americans to protect the current system, then we must reconfigure that system, as we must protect the ownership rights of the current citizens of Tennessee and the United States. We need to do this today. Thank you.
Thank you, sir. While we're out of session, does anybody on our committee have questions? Chairman Keesley.
Thank you, Chairman. David, you mentioned in your 5, as well as Don, big banks. You referenced that a couple of times, both of you. Well, what about our community banks across rural Tennessee? How would they be affected, or if they will even be? Donna, you're raising your, if I'm.
Chairman,
Recognize, sir.
Chairman, Representative, that's a very good question. The changes to this law, the beneficiaries of this law in your state are not your state chartered banks at all. That was borne out in the Lehman Brothers JP Morgan bankruptcy case after the housing collapse in 2007-8. Once the judge got through the point of working through this Article 8 issue and finding out that that JP Morgan had the ability, the authority to take those assets, in the judge's words, what was left was to determine whether JP Morgan was in the protected class. That's the term he used. So it's the protected class banks that are the beneficiaries of this law. Some might call too big to fail, GSIBs, globally systemic important banks. It's the big boys. It's one of those questions like, if you have to ask if you're important enough to be protected, you probably aren't. So it is a really good question because, fundamentally the banks in Tennessee, the independent banks are really just as much at risk as individual investors and state pension funds. Any investments that the banks hold in the system, this is through an intermediary in a digital form, they're all susceptible to this pooling issue. So your local banks should be very interested in this bill as well.
So essentially, the lenders being protected are the secured lenders of the securities intermediaries. In other words, these are the lenders to the Charles Schwabs, to the Morgan Stanleys, et cetera. And Tennessee community banks are not lending to those guys.
Gotcha. Okay.
Representative Keesley, you got another follow-up?
I do, but I'll wait till Chairman Halsey returns to the podium. Thank you, though, Mr. Chairman.
Yes,
Thank
sir.
you, and thank you, gentlemen. Thank you.
Thank you all for being here today. I've got a question. For you, and it's my understanding, talking to the bill sponsor, who we have a great deal of respect for. Let me get that on the record. My question is, has this been presented in other states, and has it been adopted in other states?
Chairman? Yes, it has been presented in other states. Last year, we got onto the issue very late. It was about January of last session that we got started, and we only had it introduced in South Dakota and Tennessee with Representative Halsey. It was moving along very well, as he mentioned. He can elaborate on that, what happened there at the end. So there was just the two states, and it was defeated in both states. Summer study supposedly here, and then defeated in South Dakota. This year, it's been introduced in North Dakota, South Dakota, Montana, Wyoming, Mississippi, Connecticut, Pennsylvania, Tennessee, obviously, and maybe a couple of others. It has been defeated again in South Dakota and in Wyoming. It is going to be studied in North Dakota, and it's still moving forward in the other states that I've mentioned. In some form or another, it's still moving forward. The issue comes down for the smaller states is there are threatened unintended consequences of a state that sticks its neck out and passes this. They're kind of vague consequences. They don't really get too specific, but there are threats. And I think if you play back the full committee from the House last year, you'll see that this body was threatened and the state was threatened with withdrawal of financial services, which is crazy to me. So the small rural states really have an issue with that. That was number one issue in South Dakota and Wyoming, why they didn't want to move forward. They were kind of hoping there was at least a couple of states or, maybe one of the big ones. Mr. Tice is working on his friends in Texas. We're hopeful that we move forward in Texas. But to answer your question, those are the states it has been introduced in, and so far it has not passed in any of them.
And again, to add to that,
You're recognized, sir.
yeah, sorry, Mr. Chairman. I would say I became on the scene late, but from what I understand, the big financial institutions really ganged up in size. And frankly, there's a documentary out called Stop It, The Great Taking, that goes over in some length about some of the potential threats, so to speak, that came down against lawmakers in the state.
I understand. Oh, and welcome today for here all the way from Texas.
Thank you.
We're kind of fond of Texans. Y'all might be speaking a different language if it wasn't for a bunch of boys from around these parts. Anybody else have any additional questions on this for these gentlemen? Speaker Marsh.
Thank you, Mr. Chairman. I was going to ask that too, what states had passed it, but I'd like to also ask, has what you're telling us to guard against, has it happened before, and who has been harmed?
You're recognized, sir.
Mr. Chairman, Representative, yes, it has happened before in a sense. We've mentioned the Lehman Brothers collapse in 2007 and 2008, and the heels of the housing issue blew up. In that situation, Lehman Brothers had borrowed money from J.P. Morgan. J.P. Morgan was the bank. Lehman Brothers was the borrower, and another division of J.P. Morgan was the custodian, just to kind of get the players lined up there. So the division of J.P. Morgan that was the custodian of Lehman Brothers assets. So on the eve of the Lehman Brothers filing for bankruptcy, J.P. Morgan, as custodian, was able to sweep those assets, shut down those funds, close them. And they were allowed to do that because of this law and because of a change in 2005 to the U.S. Bankruptcy Code. It was called a safe harbor provision. And it sounds good. Sounds like you'd like to have safe harbor, but it was safe harbor for the big banks. Like, if it's starting to rhyme, you can see where all these things are going. So in that situation, when Lehman Brothers failed and J.P. Morgan took all of the Lehman Brothers assets, that was Lehman Brothers' own assets and the assets of their clients, because they're all in a fungible pool. They don't know who it belongs to. So all the assets were frozen. Now, the opponents will say nobody lost anything in the Lehman Brothers bankruptcy, but that's a bit of a stretch. For a period of time during a significant financial crisis, individuals, retail customers couldn't get their money out. Took about 2 months, and the bankruptcy trustee facilitated a trade of Lehman Brothers retail business to Barclays and a couple of other stable financial institutions, so that all of the individual investors' accounts got moved over and they got access to them again. Now, you could say they didn't lose anything, but they lost it for a period of time, and it was only because the trustee was able to orchestrate that sale that they got access to their funds. The institutional clients of Lehman Brothers, however, weren't as fortunate. Their assets were frozen for the duration of the bankruptcy procedure, which went on to 4, 5, 6 years. They eventually got access to their funds back because the stock market reinflated to the point that the asset values increased, and Lehman Brothers was able to meet their liability to JP Morgan, and the institutional clients funds were released. But for that period of time, they didn't have access to them. So did they lose anything? They at least lost the use of those assets for that period of time. So I would argue there was some loss there. I had that issue confirmed for me last year when I was in South Dakota. I met with the individual in charge of South Dakota's state investments. And at first he thought I was crazy, as most people are when they hear this issue for the first time, because it's such an odd thing. But as I talked through the Lehman Brothers situation with him, he said, that reminds me, we did have an account with Lehman Brothers, and South Dakota's, I don't know if it was part of their pension or for something, one of their accounts was frozen for that 5-year period. So it has happened. And that's just probably the easiest example to explain.
Thank you. Speaker Marshall.
So if we pass this, it's more than likely the big banks are not going to want to play like they're playing now. They're not going to loan money on some of these deals, I would think. And another question I'd like to ask is, what is your position, and why are you doing this? Why are you promoting this? Do you have a dog in the fight, or are you just trying to keep the dog straight?
Mr. Chairman, Representative, I'll answer the second one first, because that's more fun. It really is. It's a hobby for me more than anything. I'm not being paid by anyone to do this. We do have people around the country who have liked what our writings are and things like that, so they'll help me defray my travel costs. But my wife was a state legislator for 18 years in North Dakota, and I was chief of staff and researcher for her, because they had even less staff than you guys have. And so I was very involved in the process. She's now policy director for Pro Family Legislative Network, part of Wall Builders and David Barton. And so we've been intimately involved in a lot of these issues for the past several years. And when this one popped up, I read about it December 16th of 2023. I just said, this is a family issue. If people's assets are at risk, we got to do something. I'm personally not invested in the stock market, so I don't benefit from this at all, but I want to spread the word. I would like to see this change at the state level, because it was put in at the state level, change it at the state level, but I'd also like the awareness to be raised so people were at least aware of what the risks and strings were that were tied to their investments. First question.
Well, the other one was
the banks.
Big banks won't want to play anymore.
That's the threat. You will hear that. You'll hear that probably in about 3 minutes, that's what's going to happen. It doesn't have to happen. It doesn't have to happen at all, because as Representative Halsey said, this law only changes a couple of little tweaks in Uniform Commercial Code UCC Article 8, and it doesn't do anything. It doesn't make any change until there's an insolvency down the road. If there's no insolvency, if market keeps going the way it does, there's not going to be any change in the state of Tennessee tomorrow versus today. It doesn't change anything. Any contracts, the opponents will argue that contracts will have to be rewritten. UCC Article 8 is clear throughout that if there is a separate written agreement, a contract between the parties, that supersedes the UCC. So the contracts won't be affected. Nothing will be affected unless there's this insolvency problem that we're talking about when this insurance policy is going to kick in for the banks. So they'll make threats that they don't want to do it, but the threats are pretty, they don't have to pull out because nothing really changes, other than if the banks are only lending in Tennessee because they have access to the investors' assets in Tennessee, then they might not lend anymore. But I guess I'd argue I don't think they should have that access without the client's approval. So.
Speaker, yes.
Mr. Chairman, I also would like to respond to, do I have a dog in the fight? I do not have a dog in the fight. You know, I'm representing this as an individual. I'm a person that's passionate about making the world a better place. I put several $1 million into a documentary film about trying to protect the power grid. And so I heard about this issue, and it was obvious to me that the big banks were kind of trying to pull one over on the little guy, and therefore I wanted to protect the little guy.
All right. Thank you. I would like to, if you would indulge me in a point of order, let's not ever refer to 07 and 08 as a housing issue or a market crisis. That thing was a depression for some of us.
Yeah. And
that some of us are still paying for. So we're very acutely aware. And as far as predicting that one, when folks who, some of the housing loans that were going out in those days, you knew something had to give. So some of us saw it coming. We just thought that we could get out before it all ended. Any other questions for our guests? I know that we've got some other folks while we're out of session. Gentlemen, thank you for spending your time and effort to get here today. And if you would be available in case we have some follow-up questions after we hear from the other presenters. Thanks a lot. And I'll tell you what, while we're out of session, if we could ask for Stephen Sapinik, and I apologize if I butcher your name, Tim Amos, and Amy Heaslett. And that should have it. And if y'all could come up, we know some of you, we don't know some of you, please correct if I've butchered your name. And I'll tell you what, since let's go with 4 minutes for each of y'all. We were generous with the last presenters, and I think this is a fascinating topic, and I don't want anybody to feel shortchanged on their presentation. So who's going to start for us today?
Tim, I will.
Okay. Mr. Amos, you're recognized.
Great. Good afternoon, Mr. Chairman, members of the committee. My name is Tim Amos. I'm a state-appointed Uniform Law Commissioner for the state of Tennessee. Thank you for giving us the opportunity to make a presentation today. As a Uniform Law Commissioner, one of my roles is to help develop and promote uniform laws which provide a structure and stability throughout the country by providing uniformity. The proposal today would create a non-uniform provision, which he thinks would be to the detriment of the businesses in Tennessee. I understand the argument of the opponents concerned about some catastrophic failure in the future, but the temporal changes, I think, would be more significant. There's a lot of discussion will be on the question about priority, but I do wonder if they've overlooked what I think is as significant or more significant provision in this bill, and that is changing the jurisdiction for the contract. Under current law, securities intermediary, of which we have a number in Tennessee, have the ability, as he says, to contract for the jurisdiction that governs the contract. What this provision does is it says, no. You cannot contract for the jurisdiction of your contract. You have to abide by the jurisdiction of the customer. So what does that mean? Well, that means today is, for example, let's take First Tennessee Securities is based in Memphis, and they can rely on the stability of Tennessee law for what what their contract provides. And that contract is going to provide not just this issue of priority, it's going to provide for all the things that are in the contract: dispute resolution, arbitration, forum, all kinds of issues that you don't want to have to deal, and look out for the idea that you're going to be subject to potentially 50 state laws, or for that matter, laws of foreign countries, Canada or Mexico or wherever First Tennessee is doing business. And I'm just taking that as an example because we have many other securities firms that are headquartered and doing business in Tennessee and that are entitled to rely on the law where they choose. What this bill says as to Tennessee businesses, you don't get to choose anymore. And I think that's a fundamental problem with the bill. And it's an anti-business proposition when it applies to businesses in Tennessee. You adopt this in Tennessee, does it apply to a securities business in North Carolina? Well, probably not. So a North Carolina business might have a business advantage, and a Tennessee customer using a North Carolina business probably is not going to get any protection under this bill. But a Tennessee business might protect a Tennessee customer for argument, but would be at the detriment of also having to rely on laws in all other states. So with that, I'll let the other folks testify on the other issues.
Thank you, sir. Ms. Hazlett?
Mr. Chairman, members of the committee, I'm Amy Hazlett with the Tennessee Bankers Association. The proponents of this legislation to amend Article 8 have said that its provisions allow a securities intermediary, like a bank or a brokerage firm, to assume ownership of its customers' investment property like stocks or bonds in the event of the intermediary's insolvency. I would argue that this is simply false. Most investors today own their securities through a securities account maintained with a securities intermediary rather than holding the securities directly. This indirect holding system provides many advantages for investors, such as quick computer-based trading and secure backup of their account holdings. Under Article 8, an investor who owns securities through an intermediary has a property interest in those securities. Because the securities are not property of the intermediary, they are generally not subject to the claims of the intermediary's creditors. That is, the investors will not lose their assets just because the intermediary becomes insolvent. The proponents are focused on two narrow exceptions that apply only in special situations, and they misunderstand the purpose and effect of those situations. Exception 1 applies when the investor voluntarily consents in writing to the intermediary pledging the investor's securities. This exception is known as a brokerage margin account and allows the investor to obtain a margin loan. This is similar to a consumer getting a loan from a bank and needing to pledge something as collateral, like their CD on deposit at the bank. As you all know, without collateral, loans are typically not made. For margin loans, investors pledge their securities as collateral for the loan. If this legislation passes, investors may no longer be able to pledge their own securities, and margin loans may not be available to Tennesseans. So for an investor who doesn't want to give up that priority, the solution is pretty simple. Just don't take out a margin loan. And then exception 2 deals with secured creditors of clearing corporations, which are companies that play a central role in the clearing and settlement of most of the security trades executed daily by investors who hold their securities through brokers and banks. Article 8 gives priority to those lenders who extend secured credit to the clearing corporation to provide the liquidity that might be needed to settle trades at the end of each day if one of the intermediaries fails to perform its obligations to deliver securities sold or make payment for securities purchased. This extension of credit prevents one firm's failure from causing a massive market disruption that would harm all investors. To put it simply, the ability to trade electronically is only available to investors because of the role of clearing corporations. If this legislation is enacted, clearing corporations may no longer be able to offer their services for securities traded electronically in Tennessee. House Bill 443 goes against free market principles and would not allow investors as owners of their securities from using them as they see fit. I ask that you oppose this legislation. Thank you.
Hi, my name is Stephen Sepanek. I am an adjunct professor at Vanderbilt Law School and a resident of Nashville. I have been teaching and writing about the Uniform Commercial Code for 30 years, and for 3 years chaired the UCC Committee of the American Bar Association. I'm here at the request of the Uniform Law Commission, but my comments and remarks are my own. This is a well-intentioned bill that addresses a non-existent problem and does so in a way that is likely to cause significant damage to commercial transactions and Tennesseans. The priority granted to secured creditors of securities intermediaries in Section 8511 applies in a narrow circumstance, only if the secured creditor has control of the underlying securities entitlements, and essentially to someone higher up in the indirect holding system. It is designed, as Ms. Heaslett suggested, to ensure that the failure of one intermediary does not cause a cascading failure of multiple intermediaries and a large-scale financial collapse. The rule is critical to the indirect holding system, which makes securities tradings in the electronic age possible. Eliminating it could be dangerous. It is also unnecessary because the concern underlying this bill is unfounded. Customers of intermediaries are fully protected by other law. Specifically, securities intermediaries are regulated, audited, and insured. The regulations prohibit them from using customer securities and entitlements as collateral for the intermediary's own debts. The audits ensure that they do not violate those rules. And the insurance protects customers in the event that somehow an intermediary violated the rules and that violation went undetected. Collectively, these protections have been effective. Although some securities intermediaries have failed since Article 8 was revised in 1994, no customer has ever lost out due to the rules of Section 8511. The proponents of this legislation talked about, well, they weren't able to get their accounts. That's a function of the bankruptcy code and the automatic stay. That has nothing to do with Section 8511. Sections 1 and 5 of the bill in front of you would change what law governs the relationship between a securities intermediary and its customer, and what law governs the perfection and priority of a security interest in a securities account or security entitlement. The proponent of the bill suggested when he first spoke today that that means you wouldn't have to litigate in New York. That's a mistake. That confuses choice of law with choice of forum. There's nothing in here about a choice of forum clause and about where litigation would occur. This is a choice of law clause about what law applies. Changing the choice of law could potentially be disastrous for Tennesseans. These rules give assurance that regardless of where litigation occurs, every state will look to the same state's law to determine the rights of the parties. If you change this, then where litigation occurs would produce a different outcome. If the matter were litigated in New York, it would reach a different result than if the matter were litigated in Tennessee. One of the key things about the whole Uniform Commercial Code is having uniformity of choice of law rules. If you start mucking with the choice of law rules, then we really don't have a uniform commercial code at all, and it greatly impacts things. My fear is if you do this, it's not that you will find intermediaries unwilling to deal with Tennessee customers, it's that you will find intermediaries elsewhere unwilling to deal with Tennessee intermediaries, essentially boycotting Tennessee entirely. I'll be happy to answer whatever questions you have.
Representative Hale.
Thank y'all and to the other gentleman that gave testimony. Thank you, Mr. Chairman. Couple of questions, and whichever one of you three want to answer this. So would this legislation put our state in a better position?
I think unequivocally not. I think it would destroy uniformity. It would not really protect the people it's designed to protect. And as I said earlier, it deals with a non-existent problem. I think the proponents of this bill has seized upon this rule and said, well, therefore you don't own the securities that are credited to your account. But first of all, Article 8 says that you do in almost all cases. Certainly if you have stock in IBM through a brokerage, you are treated by IBM as the owner of the stock. You get to vote the shares at the shareholder meeting. None of that is affected by this narrow provision. Have I answered your question?
Okay, yeah. So next, and this may be for you also, Professor, Chairman, can I?
Oh, absolutely.
Okay. So 2 questions to this. First of all, how long has this law been in place? And then second to that, in that time frame, has there been a problem before?
Professor, you're recognized.
Thank you. So Article 8 was revised in 1994. That's the official text of the Uniform Code. Then each state has to adopt it. Every state did so within a few years, and I think it was mentioned that Tennessee did it in 1997. So we're dealing with a law that's almost 30 years old, and nobody has ever lost a dime because of this provision.
Okay.
Representative.
Thank you, Chairman.
Karen, okay. Thank you. And I'm sitting here somewhat overwhelmed with regards to the weight of the matter that has been placed upon us here. I know that our learned friend Chairman Halsey sometimes takes up weighty matters he feels very strongly about. This issue, let's just say your average Tennessean, and you know, I've got a family trust that I manage that's got some money at Charles Schwab, and I get to buy and sell within that account. And boy, let me tell you what, the last few days have been some good buying days. What impact, in y'all's opinion, would this have on somebody who just is trying to figure out when's the right time to dump the Boeing shares that he thought were a good idea, that he was going to see that the market was just swimming in the wrong direction and they didn't see? How does it affect somebody that's trying to make, if this were passed?
I don't think it would have any effect at all. I don't think the current law or the change would affect that at all.
You don't think it would damage, it wouldn't be a threat to the ability of electronic transfers?
No.
Then what would you tell me would be the worst consequence of us doing this? And understand something is that the gentleman who spoke before you, I don't view things as a threat in a business sense, because if market conditions change, then business and service providers adjust to that market change and they change their business practices. I don't consider it to be a threat of intended harm to someone if they change their business practices. Just a point. But what would this do to our marketplace?
If you'll permit me, I'm going to give a fairly long response to this question.
We got time.
And I want to go back to how the Uniform Commercial Code is created.
Oh, this is a long answer.
Yeah. I'm not going to go back to the 1950s, but
all right.
But when an article of the Uniform Commercial Code is drafted or revised, it's a multi-year process. So I was heavily involved in the revisions to Article 9 in the 1990s. There was a study committee that worked for 2 years. It was succeeded by a drafting committee that worked for 7 years. So it took 9 years to produce revised Article 9, whereupon then it's presented to the states for enactment, and they all enacted it within about a year and a half. I wasn't involved in the revisions to Article 8, but I know that no uniform law can be proposed in less than 2 years. And I'm sure Article 8, it took many years more than that. During this process, they tried to bring in all stakeholders. The Uniform Law Commission tries to work by consensus. A drafting committee almost never takes a vote of the committee members. They try to resolve all policy issues as best they can through compromise and reason. The general motto is you leave your client at the door. It's not there for lobbying, it's there to get it right. The process of revising Article 8 was extraordinarily complicated. Prior to the revisions to Article 8 in 1994, the system was primarily paper-based. People owned stock certificates and bonds in paper form. My dad did. When he died, I had to deal with negotiating all of those paper forms. It was ridiculously complicated, which made trading on the New York Stock Exchange, there were days when it would shut down for half a day to let the paperwork catch up. People don't remember this, but it actually had to do that. The revisions to Article 8 in the 1990s facilitated what's known as the indirect holding system. by which we have large institutions, the Commercial Clearinghouse, do I have the name right? Is that what it's called? Which is based in New York, basically is the titular owner of pretty much every security in the country. But on its books and records, brokers hold them, and on the brokers' books and records, the brokers' customers hold them. This allows securities to be traded almost instantaneously, but the brokers still have to settle up at the end of the day. And the process by which they settle up is unbelievably complex, because it doesn't mean they first, within each broker, they sort of net the transactions. If a broker has some customers selling IBM stock and some customers buying IBM stock, it'll only report the net change to its intermediary. And each intermediary will do the same thing. And so you get through, you try to minimize the number of actual changes. This facilitates the whole system working. As you can imagine, it's very complicated. Now I have to get back to your actual question, which I'm talked so long I've forgotten what your question was. Forgive me. Oh, how's this going to
affect someone who's just sitting at home,
right,
managing funds for themselves via a platform on the internet?
I think largely it won't, but for one thing, and that gets back to the choice of law rules. I'm very concerned that if you change the choice of law school, Commercial Clearinghouse and all the other larger intermediaries are not going to want to do business with a Tennessee intermediary. Now, if you're dealing with Schwab, that won't necessarily be a problem, because it might not, it's not a Tennessee intermediary. It's probably located in New York or Delaware. I don't know which. But this would purport to change the law governing your relationship to Schwab. And I guess the jury is out on how Schwab is going to want to deal with that, because Schwab has its own parties to deal with, its own counterparties, and they're going to want to be able to rely, when they deal with Schwab, on the normal rules applying. And if the normal rules don't apply, that's going to give them pause to wanting to deal with Schwab. So I can't say it's going to wreak disaster, but it can do no good, and it could do a lot of harm.
All right. Thanks, sir. Anybody else have anything they'd like to add to that? Anybody have any other questions for our folks? All righty. Appreciate your time. Thank you for sharing your thoughts. We're going to go back in session, Mr. Sponsor. And does anybody have any questions for our bill sponsor? Chairman Keesley.
Thank you, Chairman. Chairman Halsey, has any F&A Treasury here in our state, have they come out in opposition for House Bill 443 here?
Sponsor.
Thank you. Our treasurer last year, when we ran this bill, was worried about it because he had studied up on it. The book, The Great Taking, that David Webb wrote about this and the danger of it, he hadn't read yet. In the meantime, he talked to several banker friends of his and asked if we passed this bill, would it do harm to Tennessee? And the bankers that he talked to said, well, it could. And he said, how? And none of them could give him an answer. So this year, he didn't opine one way or the other on it. If that answers your question.
Yeah, well, it does. So,
Chairman,
if I may. So they've deferred then.
Yes.
They haven't come out either thumbs up or thumbs down then,
Right.
at the moment. Then F&A, have you heard from F&A then?
Not a word.
No. Okay. Or any other department? Anyone else?
No.
Okay. Chairman, thank you very
All
much.
right.
Thank
Thank
you,
you.
Chairman Halsey.
Anybody else? Well, if y'all would forgive me for a moment, I'm going to opine on this matter. This is a complex issue, and we have two groups here that feel radically different about it, and both of groups of these people are obviously very competent in their roles. And so what we're trying to decide here today is who's right and who's wrong. And when I look around and I see a trucking magnate, and I'm a engineer and real estate broker, and I got a friend down there in the internment business and a healthcare executive, I feel right now, I feel ill-equipped in this because I'm overwhelmed by the impact of what this has to be felt on because of the unknown. And in these instances, I personally retreat to the position of do no harm. And between this, the only position that I know is do no harm. But if I listen to the protagonist's view on this, then it is harm by not doing anything. So I understand both of those positions. But I do know that I do not have the knowledge base. And with us being citizen legislators, we're taught to rely on our common sense and life experiences in which to render decision on how we deal with matters such as this. But this is one that's frankly beyond my expertise, and I've never been asked, even in my days on being on a community bank board, I've never heard about the great taking or the priority in a case of a bankruptcy. And so right now, I am of the, if this thing were to go to a vote today, I would have to vote no, not necessarily because it's a bad idea, but because I don't know what the right thing to do is. That's just me shucking it down to the cob and being as transparent to the bill sponsor as I can be. I'd like to hear from the other sponsors, because at the same time, for us to defer this and kick this can down the road and us find ourselves in the same position 1 year from now, when the sponsor may file another bill, I don't think that's right either. So if the committee would indulge me, the way I'd like to resolve today's matter would be to roll this bill until the final calendar of next year. And in the meantime, I would, like I said, I have a great deal of respect for this man, that I would do my best to get up to speed to where I can cast a vote with certainty of how I feel of whether or not it's a good move or not. I'm sensitive to this matter because I have a piece of legislation that I've been trying now to get done I'm on my third year of it. And what happens is that in the manner in which we present bills and the time that we have to present them, I'm not doing a good job of conveying what I want the people voting on the bill to understand and know what I know. And so that's part of what it's coming full circle for me. And I'm understanding how people that I'm trying to convince, at the end of the day, I have to say, just trust me. And that's not good enough to get votes at some point. So what I would like to do is say, but if the committee, if there's objection to this among the committee members, I would certainly respect y'all. Okay, you'd like to vote it today? Yeah. Okay, all right. All right. Well, that's fine by me. All right. Well, if we don't have any more questions, then I think I've said I'm not ready to vote for it today. I might get there in the future, but not today. But that's okay. I have very learned people up here along with me. So anyway, with that, if there's no objections other than my own, but I play well with others, Chairman Keesley. We'll vote this. Let's open the board for voting to send this on to full commerce. Let your votes be cast. Madam Clerk, tally the votes.
Mr. Chairman, you have 1 aye and 4 noes.
All righty, we have the bill fails, but I tell you what, Chairman Halsey, I'm gonna learn about this because I don't like for ignorance to be my guide and not feeling comfortable about the way I'm voting.
I'll help you. I'll help you.
I know you will. Thank you. All right, yes, sir. Next up, in front of us, is the former esteemed chair of this august body, Chairman Powers. you're here to talk to us about House Bill 775.
I am. Thank you.
All
And
right,
Ms.,
your proper posture, sir. Please share with us
I
what
can
you're going
see
to do.
that our committee that I formerly chaired has really improved. I just want to let you know that before I present this bill. House Bill 775 proposes to raise the acquisition charge for A loans from 10% to 12, and existing rate for B loans bracket from 34 to 36%. The last increase on the acquisition charge was in 2012, and the last increase in the Part B loans was 2017. The increase will support improved service and access to credit for underserved and unbanked populations. It also increases available interest rates, enabling more loan offers to previously ineligible customers. The bill does not raise the rates for an existing customer and will help provide more loan opportunities to all the customers. And with that, Mr. Chairman, I'll be glad to take any questions from the committee.
All righty, thank you. Have we got any questions for our bill sponsor today? Representative Hemmer, you're recognized.
Thank you, Chairman. Can you explain the difference between a Class A and a Class B loan,
Mr. Sponsor.
please?
Okay, yes. Thank you. The Class A is for the traditional loans that have an interest rate like that and doesn't have a cap. Class B has like a $2,000 cap. Class B, they also look more at your debt to income ratio, where Class A is more looking at like a credit score type situation.
All righty. Do we have any further questions? All righty. Without any objections, we're going to vote this all in favor. Well, I'll tell you what, Mr. Clerk, put us up on the board. And if you want to say aye, you can say aye, because like I said, it feels good to say aye again. Aye.
Mr. Chairman, you have 4 ayes.
All righty, thank you. Hey, y'all don't go anywhere. We're getting pretty slim on our forum now. All righty.
Thank you, Mr. Chairman, committee.
Thank you, former chairman. Is that a title people we can throw around
I
here?
do like that title, yeah.
All righty. House Bill 911 by Representative Garrett has been rolled. Excuse me, former chairman? You're off to full commerce. I hate for people to infer things. All right, House Bill 911 has been rolled for 2 weeks. House Bill 420 by Chairman Rudd, he has had to go run another bill. We're going to roll that until he makes his appearance back here again. House Bill 1379, I believe, has been taken off notice. Taken off notice. Well, I guess Chairman Rudd and Representative Hale are going to be in a battle for who can get back here first. Those are our last 2 agenda items. So with that, we will take. Johnson. Oh, wait, 1216. I did not see 1216. We're going to roll that 1 week. And we are going to take a 5. Yeah, we'll take a 5-minute recess. 5-minute recess. Okay, that concludes our 5-minute recess. We've got a bill sponsor back here with us, so I will declare us back in session. We are going to hear Bill 420 by Chairman Rudd. You got a motion and a second, sir. Please tell us what 420 does.
Thank you. As you recall, a couple of years ago, we passed the Consumer Protection Act, and that was more aimed, at my understanding, at more written contracts, and it's more wide sweeping. But with the change of the technology, the internet, and online subscriptions and online renewals and et cetera, has complicated that. So this is attempting to rectify that, and I have been working with the all the different stakeholders and continue to receive advice. Most of the ones who needed and explained their situation of needing removal from it, like utilities and banking and finance, we removed because we didn't want to jeopardize someone's lights being cut off or anything like that, cable, et cetera, all that, those have been removed. What this does, the goals of this Tennessee Consumer Protection and Subscription Renewal Act is to protect online subscribers from predatory vendors. The major themes of the automatic renewal subscriptions remain clear and conspicuous disclosures: express, informed, and consumed consent, and easy cancellation. A lot of the the small number of both large and small companies are doing is when you take out a subscription or you sign up for a service, what they're doing is in the fine print, which they don't tell people up front, is that whether they have a right to cancel, whether it's a year, whether there's a penalty, and also gives no, in some cases, gives no right to cancel your subscription without a penalty, et cetera. So what we're trying to do is rectify that and bring this in line with what we've already passed into code. And that is the main thing that it's trying to do. We want visible and we want acknowledgement. If you're going to use someone's credit card for a service or a subscription online, we want to make sure that they stand. So it needs to be in bold print, needs to be acknowledged, yes or no. And that's all that we're really trying to accomplish with this, make sure it's transparent and visible to protect our consumers. Now, I can briefly go through some of this and what we're doing and what is already covered in Tennessee code and what we're applying. And then I'll be happy to take any questions. What we're doing here, let me go back. There's one part of that due to two people that we've asked, and it's a duplicate we're going to take out. Oh, by the way, we have an amendment that we need to put on the bill. I forgot about that. 4217.
All righty. Could you tell us a little bit about what it does?
What this does, it does two things. The amendment, let me get to it. The amendment does two things. And number one, it removes and sets out what I just said, those utilities and subscribers and et cetera that we're taking out that we don't want in the bill. It removes those. It also moved at the request of several of the consumers to meet their needs. It removes, it replaces the July 1st with December 31st, 2025 when it goes into effect, that way giving them time to contract, to have contracts, to have their websites changed and have the coding put in and change their documents. So that was the two main things that this does in this amendment.
Do I hear a motion on the amendment? Yeah. Motion and second. All those in favor of adopting the amendment and attaching it to House Bill 420, please signify by saying aye. Aye. Any opposed? No. We're amended. All right, sir. Continue.
All right. Thank you. As I said earlier, what we just voted on what you just voted on, the financial institutions authorized, Public Utility Commission, Federal Communications Commission, Energy Regulatory covering power bills, those have been removed from the bill. What the bill does in the remaining bill, it aims to, let me get back to the bill. Excuse me. Under Tennessee Code 447-18133A1 and A2A, it requiring provision of clear and conspicuous terms of these agreements, which is already in code. This brings online into that code and including details of whether a discounted promotional price, et cetera, discounted price, period ends. I have talked to one of the people that pointed out something, which I'm still negotiating with them, is possibly removing the part where you have to confirm on a free subscription or a free, like 30 day, you get a free trial subscription, then it goes into effect, and use their credit card. I was going to take that out, and I'm still considering taking that out. If I would do that in full. I'm still negotiating with, I've got about 10 different people that wants minor. Most of the people who have contacted me are not asking to be taken out or want major changes. They are actually suggesting corrections or clarification so it's easier to read based on other bills like this passed around the country. So I said I'm open to listening to them. So if there's any other changes, there'll be minor tweaking. And in order that the Senate has shortened their date, I'd like to pass this out and then make any small tweaks later. But what it does, it requires businesses to make automatic renewal continuous service offer present to material terms and offer of the consumer in a clear and conspicuous manner. We just want to make sure that the consumer, if they're going to do anything, if they're going to take your credit card, if they're going to have an automatic renewal after 1 year or a certain period of time, or after a free trial, that they do it in a clear and present manner and you acknowledge it, that you agree, rather than just hidden in terms at the bottom that you didn't know. It also, and most importantly, establishes a penalty for people who knowingly mislead and cheat or commit fraud. And that is a $5,000 penalty per occurrence, and putting that in code in that section. And the rest of it, I'll be glad to answer questions. It's like I said, it also has to have a clear, and in line with Tennessee Code now, it has to have a clear means of canceling your subscription, which is in line with Tennessee Code now. So we're trying to fall in line with what is in written text and do this online. And I'll open it up to any questions.
Representative Hemmer, you're recognized.
Thank you, Mr. Chairman. Just looking at the bill, just curious, can you define what a service provided by business, which is I guess this is section, well, it's in section 1 of the bill, but it's basically what's a franchise issued by a political subdivision of the state?
Sponsor.
A franchise of a political subdivision of the state. Let me get down to there.
I'm looking in 4A.
Get over to the bill. All right, which
I first page on the amendment I-4A.
Provides a separate notice, thought I meant renewal. You can ask legal, but it's my understanding that it is the state itself. If there is a subdivision of the state itself of government, it wouldn't be the private sector.
Okay.
Is that, you can ask legal if that's correct. I think that's my meaning of it, but.
Thank you, Mr. Chairman. I get what you're trying to do. I definitely have been confused and have had the renewals of subscription or something. I've done a free trial and it keeps going. And so I get how they can, can trip people up at times from a consumer standpoint. But I guess from listening to your comments, it seems like you still had some work to do on this bill, and there's still some people that are still trying to work some things out. So I didn't know with that going on, is it be worth, bringing this back next week when you have it a little bit more fully dialed in?
Well, I'll leave that up to the judgment of the committee. The work that has been suggested by the stakeholders that are working with them now, such as Adobe and Spotify and some others, are really making minor tweaks. They're concerned not on what the bill's doing, but they're making sure that the vendors, they've suggested a couple of minor sentence changes so the vendors would have a better idea of what the law is. Of course, most of our law is already in code. We're just applying it to this part of the Consumer Act on online activity.
Thank you.
So that'd be up to you. The only what I wouldn't even say it's substantive, the only paragraph that I'd be dropping, which I will drop next week, and the next amendment, couldn't get it in a timely manner, as I've agreed with the Motion Picture Association and the Music Association, is to drop the free trial subscription period. Since they would then have to duplicate their work. If they did a card and agreed to the card, then under the different part of the bill, they'd have to do it a second time when the actual real subscription began. So I didn't see a need to have them do it twice. So the bill is already covers that. So when a free trial subscription period ends, the present law and what the bill does would cover that, making them sure that the real subscription, they'd have to acknowledge it. So I didn't see a need to duplicate it. That's the only major. The rest of them they're just talking about is changing actual words, 2 or 3 words here and there. And there's only been about 3 changes so far. So I didn't see any major reason to hold it up. Especially, I'm hesitant since I leave it up to will of the committee, but since the Senate's moving and wanting to get out of here, I want to make deadlines, and they usually won't activate their bills till we get it out of subcommittee. So that's one of the reasons why I was wanting to do that.
Okay. I have a question for you.
Yes, sir.
With regards to the consumer's affirmative consent to the agreement containing the automatic renewal offer terms or continuous service before charging the consumer's credit or debit card, I assume when I send them my credit card information that they're going to use that to charge me for the service that I'm enrolling in. I don't understand why we're placing more requirements on people than if I send you my credit card with the CVV and the expiration date, I know that I'm buying something. I'm not thinking that people are just verifying my credit from that. My question is, give me a for instance and give me a situation that this would prevent where something as bad has happened to somebody and that this bill would prevent it.
Well, 2 things. Number one, this is already in our current, that terminology is already in our current consumer protection. So we're just applying it here. What it would be is not just to join, but if you'd be surprised how often I go on to buy something, they ask for my credit card. Nowhere in the questions, of course, there's always a long list behind that nobody reads. Nowhere does it say in there, and this happens extremely, I would say probably 30 to 50% of the time be my estimate. Let's say that I don't know, they're certainly not guilty of it. Let's say that I joined a big box store and I gave my credit card to become a member of the big box store. And my subscription to that membership is good for 1 year. At the end of the year, they should contact me and say, do you want to read? But a lot of them, without my permission, go ahead and use it anyway. And what happens is you're deducting either monthly or periodically from your credit card, and a lot of people don't catch it for a year. So that's one instance, but sometimes you have monthly subscriptions and not everybody goes in and checks their checking account if it's off a debit card. Nobody goes in and checks it. So they're automatically deducting and the consumer doesn't know because they no longer have a need for a service and they thought it expires, but they automatically renewed them and started using their debit card or credit card. That's what this is aiming to protect. And that language is already in Tennessee Consumer Protection Code, but now it will apply to online activity.
Yeah, Mr. Sponsor, you confuse me a little bit whenever you say, well, it's already existing code, but we've got it in this bill here today.
Well, again, this is covering online activity. The consumer we passed is in written agreements. So I'm just playing it safe and making sure it's in code because right now the vendors are not abiding by this. We're trying to make it so the vendors are not making it plain, a yes or a no, or letting them know in bold print, here's what we're going to do. So we're trying to make them do that online.
Okay.
We do it in a written contract, but it's not really, it's kind of vague whether they do it online. So I'm trying to put it in code.
Speaker Morris.
Thank you, Mr. Chairman. I've got 2 or 3 questions. You're taking a lot of people out. Who's still in? And let me go ahead and ask them. You can, who is having the problem now? I haven't heard of this problem. And we're talking about there's lists that you don't read or you can't read, or there's a big list on everything you buy. You buy a car, you got a book you don't read. So, I mean, you got to trust all that. And I have several subscriptions and I look at mine every month on my bank account. You know, maybe I'm different, but I just want to know what I've got and make sure that it's not bigger than it's supposed to be. So what problem do we have now with this?
Well, excuse me, the who we took out are government entity or government controlled license entities, such as utility companies or their competitors in the private marketplace. So we took them out because they provide utility services, banking services, mortgage services, medical services, and we didn't want to jeopardize their services, and they are regulated by government. So we left that separate. Plus, they have written agreements as well. The problem is a lot of the times online, no, there is no agreement. They don't do it. They just automatically do it. And we're saying that you can't just take someone's credit card. You can't take Pat Marsh's credit card when he joins ABC Company or ABC Service or Getty Photo Images or Adobe or Microsoft or anything like that. Any company, you can't just do it or sign up for Fandango movies or download music. You can't do it unless the consumer knows you're going to keep his credit card, and they don't tell people. They just keep it and keep adding to it if it's a monthly or a periodic renewal. And we're just trying to say that, like they would in a written agreement, which people read written agreements, but they don't read the 2,000 or 3,000 words in small print that's attached to the bottom, unless it's a major investment. We're trying to say they have to let the consumer know like they would in a written agreement. Like if you were going to close on a major deal or you were going to sign your signature or piece of paper, in most cases you read that paper because it's in front of you. But online it's not in front of you and people don't know where to find it and they're not told what they're doing with it. We're trying to say here that online you have to treat people like you do with written agreements. You have to abide by the Tennessee Consumer Protection Act that's in place now. And we're adapting that same language to cover online.
And who has got the problem now?
Well, I've been contacted by numerous consumers, and I've had it happen to myself over the years, both in the past and, well, relatively recently. I'll give you one example of mine. I can't give you an example of everybody that's had it. This has been an online problem. I had a lot of people contact my office thanking me for carrying the bill. Give an example. A year or two ago, about 2 years ago, I signed up for a photo download where I pay so much a month and I can cancel anytime I want. When you sign up, you said there's subscription A, subscription B, subscription C. They all have a different price and they tell you what they do under each one. I chose one where I can subscribe at a certain amount anytime. Well, I ended it and they said, well, you can't end it. You signed up for 1 year and you owe us the remaining 6 months. And I said to them, where is that? And they couldn't provide the proof. Of course, they didn't take any action because they were lying to me. I said, well, the service that you said that I signed up for is a higher price than what I'm paying for. If I signed up for an automatic renewal at a higher price, then why am I paying a lower price? They never answered me. But I question, if you do that to a senior citizen or someone that doesn't know, they're going to be taken advantage of and pay the bill. And they didn't know it. So that's what it is. And a lot of times people don't know they can't cancel a subscription. Most vendors with online services, whether they're a major corporation, it's set that you're downloading a monthly service, you pay for the service. If you don't pay, it's canceled. And that's the end of the matter. Whether it's AT&T, whether it's somebody else, AT&T is excluded from this because they're a utility. They provide high-speed internet, which is why they're out of it, not because of their phone service. But they don't let you know and they just bill you. The real fraud comes in where they never tell you. It's not in any written agreement. It's never in an acknowledgement. It's never in a term. You sign up for it and they just keep billing you. And you try to cancel. The only way to cancel, since they have your number, is to go to the bank, change your card. So they can't charge anymore. And people shouldn't have to do that. That's actually what I had to do 2 years ago. I had to go and get a new credit card, a new debit card, a business credit card, because they just kept billing each month, even though I told them I didn't want the service and they wouldn't acknowledge me canceling my service, which was in my agreement. And I mean, how many people are going to spend the thousands of dollars to hire a lawyer, the consumer, and go sue them and take them to court? So this is, like I said, this is trying to bring both online and written agreements so that we agree to the same thing in same codes. That was the idea. And so much that we have in code will apply to this since it's in the bill and reference to the bill.
Speaker Marsh, has this legislation been done in other states? Looked like to me it probably, like we were just talking about UCC, is universal is what they're looking for. It's the same thing in every state. So if we change it here, it looked like to me it would mess up the whole system for some of these folks.
No, it wouldn't mess up the system. And it has been passed in other states. Consumer protection, online prescription, they're varying right now in different states, whether it be Colorado, California, New York, and other states is passing some form of this. Unless Congress passes it, which they haven't yet, it would override everybody and have a national standard. We don't have that yet. And I just feel we need to protect Tennessee consumers.
Thank you.
I want to clarify, you said California had passed this?
Not this bill, but they've passed a form of online subscription.
Okay. Chairman Keesling.
Thank you, Chairman. I'm getting the itch. I think it's time for us. Are we getting close to adjournment here?
Yes, sir.
This committee. Okay. Chairman Rudd, I've got some questions that I'd like to dovetail off of Speaker Marsh, but I know time is of the essence. I don't think you would be offended. I'm going to make a motion to roll this one week, Mr. Chairman, and we'll just see how that falls in.
I second that. I was beginning to feel the same thing because I think that I'm not a weather forecaster, but I was picking up cold winds through this committee that I think the sponsor, can address with getting this thing changed around, because I do want to find out what the ultimate disposition of the free trial is, because the de facto position, if you make it that difficult to run a free trial, there just won't be any free trials for people. That'll be a choice that providers, or that would be my choice.
Yes, I've already said I'm removing that, Mr. Chair.
Okay, well, let's get it all in shape. We can get with you in the coming week and let's get it cleaned up, and then we'll take it up next week.
All right.
All right. And without objection, that's what we're doing. We're rolling 421. We're also going to dispose of House Bill 141 by rolling it 1 week as well by Representative Hale. Without objection, rolled 1 week. And then with no further questions, we are adjourned.